The blue lights flashed in my rearview mirror, and I felt that familiar sinking feeling in my gut. I pulled over, killed the engine, and put my hands on the steering wheel at 10 and 2. As the officer approached, I could see his eyes scanning the interior of my truck, not aggressively, just professionally. He asked for my license and registration, and I handed them over. Then came the question that always changes the atmosphere inside a vehicle. He looked at my driver's license, glanced back at me, and said, "Sir, are you carrying any firearms in the vehicle today?" It's a moment that separates the prepared from the panicked. How you answer that question and everything that follows can mean the difference between a warning and a felony charge, a friendly conversation and a felony stop with guns drawn. My hand stayed perfectly still on the wheel, and I took a slow, deliberate breath. But I've seen too many videos and talked to too many gun owners who don't make it out of that first minute without making a critical error. Here's a question I want you to think about right now, and I really want you to answer in the comments section below. What's the most tense or confusing interaction you've ever had with police while carrying a firearm, and what did you learn from it? I want to hear your real-world experiences because chances are you've either been in a similar situation or you've worried about it happening to you. We're going to dive deep into what really happens during these stops, but stick with me because a lot of what you think you know about your rights during these encounters might be dangerously wrong. I'm going to reveal something later in this article that could change how you handle every future interaction with law enforcement, something about how the Supreme Court has completely shifted the rules of engagement for armed citizens. Now let's roll back to that traffic stop I mentioned. My answer to the officer was a calm, clear, "Yes, officer. I have a concealed firearm on my right hip, and I have a valid permit." In that moment, I had just triggered a cascade of decisions on his part that would determine the next 15 minutes of my life. This is where so many armed citizens misunderstand the dynamic. The officer is not asking if you're carrying because he wants to take your gun, and he's not asking to start a philosophical debate about the Second Amendment. He's asking because he's doing a threat assessment, pure and simple. These encounters are not about rights in the abstract, they are about survival and safety in the immediate moment. When an officer asks about weapons, his mind is already running through a series of what-ifs. He wants to know the location of the gun, the demeanor of the person carrying it, and whether there's anything in your behavior that signals a threat. If you look nervous, avoid eye contact, or make sudden movements, those are going to be red flags for him. I remember talking to a retired state trooper who told me that when he asked that question, he was mostly looking at the driver's hands and eyes. If the driver looked at the glove compartment or the center console, that was a sign that the gun might not be in a legal or safe place. This brings me to one of the biggest mistakes I see gun owners make. They get so focused on the legal technicalities of whether they have to disclose their carry status in a duty-to-inform state that they completely forget about the tactical reality of the situation. I don't care what the law says in your particular state, I will always advocate for a polite voluntary disclosure if you are armed. It's the smart play, not just the legal one. A traffic stop is already a high-stress situation. By being upfront, you're telling the officer, "I respect your position and I'm not trying to surprise you." Now, a lot of people will push back on this. They'll say, "I don't have to tell him anything if I'm not legally required to." And you're right, you may not have a legal duty. But let me tell you what happens when an officer finds out you're armed without warning, whether through a routine registration check that shows you have a permit or because you reach for your wallet and your shirt rides up. The officer will likely back up, put his hand on his sidearm, and in a loud, commanding voice, start giving you a series of rapid-fire orders. The entire vibe of the stop changes. This is exactly what I'm talking about when I say that lawful gun owners create suspicion when they don't need to. I had a buddy of mine call me in a panic because he was in the middle of a traffic stop and the officer told him to step out of the vehicle. He was carrying legally with a permit, but he hadn't said a word about it. When he opened the car door and the officer saw the magazine pouch on his belt, the officer went from asking about his tinted windows to shouting at him to get on the ground. It turned out okay, but my buddy spent 20 minutes on the curb in cuffs while they sorted it out. He wasn't wrong from a legal standpoint, but he sure wasn't right from a practical one. The psychology of the police mind during these encounters often comes down to one primal thing: suspicion. If you create suspicion by not disclosing, you're already losing. Let's talk about the actual legal framework that dictates how law enforcement can interact with you and your firearm during a traffic stop, because there's a lot of confusion here, and I'm hearing some truly dangerous myths floating around. One of the biggest myths I hear is that if you have a concealed carry permit, the officer cannot remove your gun from its holster. That is completely false. An officer can absolutely ask you to surrender your firearm for the duration of the stop. They do this for their own safety and for yours. In many jurisdictions, if you're in a duty-to-inform state, the officer will often say, "Okay, just keep your hands where I can see them. I'm going to secure your firearm for the duration of this stop." This is what they call officer safety, and it's a concept that is protected by case law. You should comply immediately. Do not argue. Do not tell them they can't touch your gun. That's a recipe for disaster. Think of it this way. A traffic stop is a temporary detention. The officer isn't seizing your property permanently. He's just temporarily incapacitating a potential threat while he's dealing with you in close proximity. This is standard procedure in many places. If an officer tells you to step out of the car and he asks to secure your weapon, you should say, "Yes, officer. It's on my right hip. How would you like me to proceed?" This brings up the next tactical consideration, whether to hand the officer your gun or let him retrieve it. I've seen videos where a well-meaning driver tries to hand his gun to the officer, and the officer goes ballistic. I've also seen officers who are annoyed when the driver doesn't know how to retrieve it safely. My advice is this: always let the officer direct the action. If he says, "Take it out slowly and put it on the dash," then do that. If he says, "Don't touch it, I'll get it," then put your hands on the roof of the car and let him do his job. Do not reach for anything without explicit permission. I cannot emphasize this enough. Your goal is to appear as non-threatening and compliant as possible, even if you feel like your rights are being violated. You can fight the legal battle later in a courtroom, not on the side of a dark road. Now let's talk about what happens when you don't have a permit and you're carrying in a vehicle. This is where I get nervous for people because the laws are all over the place depending on which state you're in. In some states like Alaska, Arizona, or Texas, you don't need a permit to carry a handgun in your car if it's concealed, or if it's in the glove box, or if it's in plain view. These constitutional carry states generally allow you to have a loaded firearm in your vehicle because they view your vehicle as an extension of your home. But that's not the case everywhere. In states like New York, New Jersey, or California, the laws are extremely strict. You might need a specific permit just to transport a handgun, and it usually has to be unloaded and locked in a case, separate from the ammunition. This gets incredibly complicated. If you live in a constitutional carry state and you drive into a restrictive state, you could be crossing state lines and instantly committing a felony. I had a viewer write to me once who drove from Pennsylvania to New York to visit family. He had his Glock in the center console, legally in Pennsylvania. He got pulled over for a broken taillight and made the mistake of telling the officer he had a gun. That officer looked at him like he had two heads. He didn't have a New York permit, which is nearly impossible for non-residents to get, and he was arrested. His life changed because he didn't understand interstate firearm travel. This is a critical point that isn't discussed enough. Reciprocity agreements are incredibly complex. Many states honor other states' permits, but some do not. And even states that do honor them often have different regulations on where you can carry and what the duty to inform requirements are. Before you take a road trip with a firearm, you should look up the laws in every state you're passing through. It's a hassle, but it's a hell of a lot less hassle than a criminal record. Let's shift gears for a minute and talk about the Supreme Court, because there's a seismic shift happening right now that every gun owner needs to understand. We've been talking a lot about traffic stops and practical tips, but the ground underneath all these interactions is changing. There is a massive push in federal courts to drastically expand the Second Amendment using originalism, and it is turning gun laws upside down. The Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin in 2022 was a landmark. The court said that modern gun laws have to be consistent with the nation's historical tradition of firearm regulation. This meant that instead of just balancing public safety with individual rights, courts now have to look back to the founding era to see if there's a historical analog for a particular law. This has been a huge victory for gun rights advocates. But here's where I want to add a layer of nuance that a lot of people are missing. The court doubled down on this in the Rahimi case, which challenged the ban on gun possession for people under domestic violence restraining orders. A lot of people expected the court to strike down that ban because, historically, there wasn't a law that specifically disarmed domestic abusers. But they didn't. In United States versus Rahimi, the court upheld the ban, saying that disarming dangerous people is consistent with historical principles. The vote was 8-1, which is a massive statement. Chief Justice Roberts wrote the opinion, making it clear that the Constitution isn't trapped in amber and that the historical principle of disarming dangerous individuals justifies the law. Now, why does this matter to you on a traffic stop? It matters because it shows that the courts, even the conservative majority, are willing to uphold some restrictions on the Second Amendment. But more importantly, the dissent in Rahimi, written by Justice Thomas, was a scathing critique of the majority's application of the Bruin test. Thomas argued that the majority was watering down the historical analysis and making it too easy for the government to restrict gun rights. The debate between historical twin and historical analog is a critical one. Bruin said you need a historical analog, which means the modern law has to be comparable to a historical one, even if not exactly the same. Rahimi basically said that analog can be pretty broad. This is going to be the key battlefield for the next decade of gun litigation. For gun owners, this all boils down to one thing. The future of carry laws, assault weapon bans, and magazine capacity restrictions is going to be decided based on obscure historical records from the 1700s and 1800s. It's a weird time to be alive. You have to know not just the law as it stands today, but you have to anticipate how these lawsuits are going to change the law going forward. This is a level of complexity that makes traffic stops even more perilous. An officer might enforce a local regulation that is eventually ruled unconstitutional, but you're still going to have to deal with the consequences today. I always tell people you have to survive the present, even if you're fighting for a better future. Let's get back to the real-world tension of a police encounter because I want to dissect a few more scenarios that I know are common. Imagine this. You're driving with a passenger. Your passenger is legally carrying a firearm. Does the passenger have a duty to inform the officer? Usually, yes, if they're in a duty to inform state, but what if they don't speak up? What if the officer sees you acting strange, thinks you're hiding something, and asks you both to step out? This is where things get dicey. I've heard of situations where a passenger had a gun in a backpack on the floor, and the driver didn't know about it. The officer sees the gun, asks who it belongs to, and suddenly both people are detained. The owner of the vehicle might face charges for allowing a firearm to be in the car without proper storage. Another scenario. You have a revolver in your glove compartment. You reach for the registration, forgetting the gun is in there. The officer sees you open the compartment, sees the gun, and now he's screaming at you. This is a classic case of a nervous gun owner making a mistake. To avoid this, you should always keep your registration and insurance in a separate place, like a sun visor pouch or a folder in your door pocket, so you never have to reach near your gun. This is one of those practical insights that gun owners rarely hear, but it can keep you out of a world of trouble. You have to train yourself to separate your weapon from your vehicle documents. It seems basic, but I see people mess this up all the time. What about the behavior of the officer? I mentioned earlier that they're looking for signs of intoxication or aggression. If you're calm and collected, the officer will likely de-escalate. But if you start making sudden movements, talking loudly, or arguing, the officer's training will kick in and he'll treat you as a potential threat. It's important to understand that the police are incredibly sensitive to what they call furtive movements. If you start leaning toward the floor, reaching under your seat, or looking into the back seat, the officer will perceive that as you trying to hide something or access a weapon. I was in a patrol car once with a deputy, and he told me, if I see a guy reaching for a seatbelt or under a seat, I don't even think about it anymore. My hand goes to my gun, and my voice goes up an octave. I'm not taking a chance. This is the emotional pressure that builds during these encounters. The officer is as nervous as you are, even if he doesn't show it. You have to bridge that gap by being a good communicator. I've found that using a calm, slightly deeper voice helps. I always apologize for the inconvenience, even if I didn't do anything wrong. I say, I'm sorry, officer. I know you're just doing your job. I want to keep this safe for both of us. I do have a firearm, but I'm not going to reach for it. This helps the officer see you as a reasonable person rather than a potential threat. Now, let's talk about the constitutional carry states. A lot of people think that because they live in a constitutional carry state, they can just do whatever they want. That's a dangerous mindset. Constitutional carry usually only applies to residents of that state. If you're from out of state, you might not be covered. Additionally, even in constitutional carry states, you can still be charged with carrying a weapon in prohibited places like schools, government buildings, or bars. You can also be charged if you're a prohibited person. If you're a convicted felon, you cannot possess a firearm, regardless of state law. This is federal law, and it trumps everything else. The same goes for anyone who has a restraining order against them or who has a misdemeanor conviction for domestic violence. I want to bring up one more scenario that's critical. What if the officer asks to search your vehicle? This is where your rights are put to the test. You have a firearm, you're lawfully carrying, and the officer asks, "Mind if I take a look around?" What do? Many people, out of nervousness or a desire to be cooperative, say, "Sure, go ahead." That is a consent search. Once you consent, you've effectively waived your Fourth Amendment rights. The officer can now look everywhere, including your locked glove compartment or your trunk. He could find an unlabeled prescription bottle, a stray round of ammunition, or anything else that could cause you problems. You have the right to say no. You can politely say, "Officer, I have nothing to hide, but I don't consent to any searches." This is a tough thing to say. It can make you look guilty. But if you're confident in your rights and you haven't been doing anything illegal, you have the right to refuse. The officer needs probable cause or a warrant to search your vehicle without your consent. The smell of marijuana, seeing a weapon in plain view, or spotting drug paraphernalia could give him probable cause. But just asking you to step out of the car so he can run a dog around it doesn't automatically give him the right to tear apart your vehicle unless the dog alerts. This is a gray area, and it's always safer to err on the side of caution. If you have a firearm and you're transporting it legally, you should be compliant but firm. You do not have to answer all of his questions either. A common mistake gun owners make is telling the officer where they're going, what they're doing, or how long they've had their permit. These are fishing expedition questions. You can simply respond, "I'm not answering questions without my lawyer," if the question goes beyond identification. This is another secret that many gun owners don't realize. You don't need to be a chatty Cathy. Silence can protect you just as much as talking can hurt you. Now, I keep mentioning this important thing I'm going to reveal later. Here it is. The most dangerous myth in the gun community right now is that the recent Supreme Court rulings guarantee your safety during a police interaction. They don't. In fact, they can create a false sense of security. People think, the Supreme Court just ruled in my favor so I can do whatever I want. But the reality is that state and local law enforcement are often behind the curve on these rulings. They're still enforcing laws that might eventually be struck down. You could be arrested and have to spend thousands of dollars and years of your life proving your innocence in court. This is where the issue of temporarily confiscated firearms comes in. I've heard so many stories of people having their guns seized during a traffic stop, even when they had a permit. They think the officer will just give it back. But sometimes they don't. Sometimes the officer will run the serial number, find that the gun is reported stolen, or find some other issue that the owner didn't know about. Sometimes the officer will decide that the driver is a danger to themselves or others. If you express distress, or if you're clearly intoxicated, the officer can confiscate your firearm. That could be the last time you see it. You could have to go to the station, fill out a bunch of forms and wait days or weeks to get it back, or you could be fighting in court for the return of your property. This ties directly into the psychological aspect of carrying. You have to be mentally prepared to be disarmed by a police officer. It's not a violation of your Second Amendment rights, it's a temporary administrative action designed to ensure safety. If you can't handle the idea of giving up your gun for 10 minutes, you shouldn't be carrying it. The goal is to be confident enough to be compliant. This is the perfect time to mention that my previous article on how to behave during a police encounter is linked in the description below. I also want to address the issue of open carry. If you live in an open carry state, you may be wondering what happens if you're walking down the street and an officer pulls up. Your gun is visible on your hip. If an officer stops you, the dynamic is similar. He's going to ask for ID and ask if you have a permit if required. But open carry often makes people more anxious, especially if you look like a younger person or you're in a sensitive area. An officer might run your ID to check for warrants, and you might be detained for a longer period than normal. The thing to remember is that the officer has the legal authority to detain you for a Terry stop if he has reasonable suspicion that you are involved in criminal activity. Just openly carrying a firearm is generally not enough to justify a stop, but in a high-crime area, it could be a factor. Let's touch on the question of self-defense misunderstandings. This is a huge topic for concealed carriers. Let's say you use your gun defensively. You get into a self-defense encounter, you stop the threat, and you call 911. When the police arrive, you're still holding the gun, or the gun is on the ground. The officers on scene don't know who the good guy is. When they pull up and see a guy with a gun, they're going to treat you as an active threat. This is where the same rules apply. Drop the weapon, put your hands up, and give yourself up to them. You can explain later in a calm and professional manner. This is a tactical choice. You either trust the cops to sort it out, or you risk being shot by the responding officers. Now let's wrap this up by bringing it all together. The Supreme Court may be moving in a pro-Second Amendment direction, but the rubber meets the road on the streets, not in the marble hallways of Washington. Your rights are only as strong as your ability to articulate them calmly and intelligently in the face of a stern-faced officer who's had a bad day. The reason I started this article with that intense scenario was to ground you in reality. The Supreme Court doesn't get called to a traffic stop. You do. You have to be the one who navigates that interaction with skill and poise. Remember that question I asked at the beginning? I really want you to think about it. What's the most tense or confusing interaction you've ever had with police while carrying a firearm? Leave a comment below and share your story. I read them, and I learn a lot from your experiences as well. Don't forget to like, subscribe, and hit that bell for more content like this. Now go out there and be safe. And most importantly, be smart.